Hello, everyone. I'm very pleased to be here and pleased to have a hand in making sure that this event could happen. It was interesting listening to those announcements about the societies. I was trying to figure out if you decided whether you belonged in ACS or the Federalist Society, depending on whether you wanted to hang out at lunch with Richard Epstein or go to a mixer with Bert Newport. And there may be more truth to that, actually, than so think about it. So I'm thrilled to get to introduce Josh Blackman. I'm going to apologize because I'm going to do the unforgivable and introduce him and then walk out, but I had a commitment when this got scheduled that I didn't want to not meet Josh, which is kind of interesting because I've known Josh for a while now, but we just met, which is a sign of our times. And in fact, I had my assistant ask my assistant to print out his bio, and you learn things from bios that explain other things that you already know. So Josh is a professor at South Texas School of Law, and he teaches constitutional law. And I knew him when he was just a wannabe law professor, and I met him through his very wonderful blog, joshblackman.com. And in fact, I was just looking at the blog, and it's a terrific blog. It's one of the blogs that I look at, and I don't look at a lot of different blogs. He's got two things up of interest now. One is some correspondence between Elena Kagan and Neil Katyal, in which Elena Kagan was clearly, while Solicitor General, ensuring that she was able to sit on the healthcare cases. More about that in just a moment. And then a fascinating story that he was has no doubt he'd gotten elsewhere about the relative reporting rates of marriages in the New York Times for certain elite schools. So we always like to make sure that our ratings are good. And we don't come out good from that.
NYU,
yeah.
Yale overtook Harvard.
Yeah.
But Harvard has 3 times as many students as Yale. So Yale's doing really good. You're like below 10.
Yeah, but Harvard students don't get married that much because they don't all like each other that much. What's astonishing is that we're not doing better. So I need you all to get married and get into So anyway, Josh is extremely media savvy or new media savvy in a way that I think is extremely important. It's something that I actually am going to be focusing on a bit at the law school here the next year, which is how to help faculty understand that they just can't write that article and then have it read by 300 people and think that they've done their job, but that you need to learn to promote yourself and your ideas in a lot of different areas now. And Josh is somewhat of a master of that, so I picked up his bio today, and it's interesting to learn that he got his bachelor's degree, Magna, from Pennsylvania State University of Information Sciences and Technology. So it started to explain things, including why he's got this cool little, I mean, I've done a book tour, right? And I have this cool little thing you carry around everywhere. It's really cool, right? So, more to your interest, he graduated J.D. Magna from George Mason Law School. He went and clerked on the district court for Judge Gibson, and then for Jenny Boggs on the Sixth Circuit. Did you not work between that and going to teach?
No.
Yeah, okay. He runs Fantasy SCOTUS blog league, so while all of your friends are busy worrying about the NFL, he's actually worrying about something important. Most important of all, he's written a book that I've just read pieces of on the internet that he just gave me my own copy, called Unprecedented, the Constitutional Challenge to Obamacare. So the Obamacare litigation was this little case you might have heard about a couple of years ago. And I know of 2 books that have been rushed out on the subject. One of them is full of a lot of law professors pontificating, many of whom are my good friends, so I will say nothing more about that book. But this one is interesting. It's full of interesting tidbits.
I'll look on the jacket. This one's interesting.
Full of interesting tidbits about what went on. I'm glad to have a chance to meet you in person.
Thank you.
Go for it.
Mr. Friedman,
Yeah.
a pleasure.
Yeah.
And you should know that he's one of the wittier law professors. The articles he writes, especially with Dahlia Lithwick, are right on and really give a good sense of the flavor of the court. So you should read his stuff outside of class also, I promise.
I'm the right on part of that team. Dahlia is the win, so.
All right, thank you so much. And if you want to be cool like him, we're actually selling copies of the book later. And I will happily autograph them. And if for whatever reason you want to buy them on Amazon, I actually have these book plates, which I can autograph for free, no charge. I'll give it to you with the expectation that you actually will buy a book later. Understood? Okay, you just nodded assent. That's a contract, right? Okay. All right, well, I thank you very much to the Federal Society, and ACS, and NYU for hosting this. The talk today is about Obamacare. So how many of you actually studied this case in common law? Oh, wow. So the rest of you, are you guys mostly 1Ls? Have you taken common law now? So let's give a brief overview of the case. The Affordable Care Act this big, massive 2,700-page law. The purpose of this law? To make healthcare affordable. Whether it does that or not my concern right now. But the provision that was meant to make healthcare affordable was something called the individual mandate. What is this? It forces you to have health insurance. If you don't have health insurance, you pay a penalty, right? The reason why is all these young and healthy people like all of you frequently don't have health insurance. When you need it, you go to an emergency room or you buy insurance. I'm good.
Are you good?
Yeah, we're good.
Okay.
We're cool, thank you.
You're welcome.
Even better. So the mandate said, listen, you guys can't free ride in the system. You can't mooch. You can't be, these moochers. You're going to have to buy health insurance. But the problem was the mandate did something that had never been done before. It forced people to buy a commercial product. There's been lots of regulations on activity, like growing wheat or traveling between states, but Congress had never before tried to coerce activity. This made the law, in the words of Randy Barnett, who wrote the foreword, unprecedented. It had never been done before. So that's the brief common law background. But the case was much more than about constitutional law, which is why I wrote a book about it. If you want to read the common law book, read the ones by his colleagues, which are okay. This law is about politics, because this represented the president's signature piece of legislation. This is what he made his entire first term about. It's really about Congress also, because this was a law that was very bitter within the Congress. It passed by the most narrow margins. Not a single Republican voted for it, and many Democrats voted against it. This was the first time in the 20th century that a massive piece of legislation was passed on such narrow lines. The Social Security Act, the Americans with Disabilities Act, the Civil Rights Act, all passed with bipartisan support. The ACA, nothing. It's really no wonder that all the acrimony we have today exists, because it all began back then. And ultimately the case about the Supreme Court. It's something of a stunning notion that 9 judges and rogues are going to decide the fate of this massive law passed by a very popular president after a very momentous election. And at the heart, it's about the Constitution, right? This is what gives the court the power to make these decisions. And how the court construed the Constitution here resolved the case. So we all know healthcare is very, very, very expensive. And there have been several attempts to try to make it cheaper. I don't think anyone in this room is old enough to actually remember this, or if you are, you might have seen pictures of it. Anyone know what this is? How about this one? Anyone remember this? Okay, I'm your age, so you should remember this, okay? This is Hillary Rodham Clinton. In the early 90s, she tried to have some form of universal health care. It was very unpopular. There were commercials like this with Harry and Louise, which were meant to try and scare people away, saying, we don't want this health care. The Clintons failed and went down. And this was in part how the Republicans took the House in '94. But healthcare remained expensive. When the president was inaugurated, he made his main policy to enact this Affordable Care Act. He knew it was going to be unpopular, but he wanted to do this because he thought this was the right thing to do. So from the moment he was sworn in, actually, this was, everyone know that? The president holds a record with FDR. The only president to be sworn in 4 times. Roosevelt was sworn in 4 times because he was elected 4 times. Obama was sworn in 4 times because of a weird thing. So the first time, they flubbed the oath. Remember that in 2009? Actually, what happened was, Roberts was saying something that Obama jumped the gun and they got all mixed up. So they did it again, right, in the White House later. Fast forward to 2012. The Constitution says that the president's terms begin on a certain date. This year, that date fell on a Sunday. They actually did it twice. One's for real, one's for show. So he's actually been sworn in 4 times. He actually holds a record with FDR. But from the moment the president was sworn in, he made his main goal to try and cut healthcare costs, which became this Affordable Care Act of 2010. No one ever remembers the patient protection part. I guess that's been dropped in vernacular. But when this law was being passed, it wasn't so popular. There was a very strong social movement. I'm sorry Professor Friedman had to leave because he's written about this so greatly. But in constitutional law, there's this notion that the people interact with the Constitution, that they're really very cohesive forces. He calls it the will of the people. But there was a very strong social movement that formed called the Tea Party. We all remember this is fairly recent. And the Tea Party rallied around opposing Obamacare. Now they didn't just oppose it on policy grounds, saying we don't want socialized health care. They opposed it on constitutional grounds, which makes this unique. They were trying to embrace themselves and wrap themselves in the United States Constitution to try and stop a massive law. They realized that they couldn't stop with the legislative process. If you remember, in 2009, Democrats had 60 seats in the Senate. We all know you can't have a filibuster with 60 seats. As long as the Democratic caucus stays solid, there's no filibuster. The House was overwhelmingly Democratic. There was a serious vote majority for Nancy Pelosi. This was a fait accompli. Yet, thousands and thousands of people across the country marched and rallied to try to stop this law, saying this is unconstitutional. Congress cannot make us buy health insurance. Hello, come in. So what's happened? We go back to the Congress. And it falls to this man, Senate Majority Leader, perhaps not much longer, Harry Reid. Harry Reid was in charge of getting the bill through the first round in the United States Senate. This was the actual bill. Does anyone know how long the Affordable Care Act is? Anyone? I'll give you a hint. It's about roughly the size of 2 copies of Atlas Shrugged. It's actually a little bit longer than that. It's about 2,700 pages. They have those little margins though. It's 2,700 pages. This is what it looks like. This was the Affordable Care Act. This law was mostly written behind closed doors within Democratic strategic conferences and was not released to the full Senate until probably at the beginning of December of 2009. When the law was released, there was not going to be much debate on it. Why? Because the Democrats had 60 votes. The president made the decision saying, listen, we have 60 votes, we're going to push it through. We're not even going to bother trying to get the other votes. He made efforts in the past, Republicans weren't interested. This might have been a time for him to say, well, maybe this isn't the right time, but he wants to do it, hope and change, whatever. So they went to go pass the bill at the last minute. Of course, no one actually read the bill. I love this cartoon. It says, all in favor of health care, aye, the bill passes. Now, does anyone know what's in it? And this is not just satire. If you recall, a reporter asked Speaker Pelosi about the law. And she said, we're going to have to pass it to find out what's in it. Think about that. The Speaker of the House said, we're going to have to pass it so we can find out what's in it. Next time any of your professors ask you to look at legislative history or consider legislative intent, point to that statement, because they got one. It's whatever happens. And we've actually had, since the law has passed, about 8,000 new pages of regulations passed. The stack's actually about can't reach, about 7 feet high. You stack all the papers head to toe, all the regulations. But something happened with the law. This guy, Senator Ted Kennedy, passed away in 2009. He was the 60th vote in the Senate. Now, he's from Massachusetts, right? What's the big deal? Of course the Republicans are going to replace him. Of course the Democrats will keep the majority, right? No. Who's this? Scott Brown. Scott Brown ran as a Republican in Massachusetts as the 41st vote in the Senate. Let me say that again. He ran as a Republican in Massachusetts for the sole purpose of stopping Obamacare. He was elected. This was a very unpopular law. We're talking about Massachusetts. It's one of the bluest of the blue states, but he won. And with that, the Democrats lost a filibuster. So we had a problem. Problem for this lady, Nancy Pelosi. What was the problem? The law could not go back to the Senate. The second the law goes back to the Senate, it'll be filibustered, it'll be dead. So they had to take that draft version, that 2,700-page monstrosity, and then send it right to the House and pass that one. But the problem was that people in the House weren't happy with the Senate bill. There were all these other provisions they didn't like. If you remember the Louisiana Purchase, the foreign customer kickback, these are all things they didn't like. So this guy had an idea. He always looks very tan. We'll get to that later. And we had a huge clash in the House. This is actually the bill. I love this picture because you kind of see the top thing. The bill had lots of extraneous positions, speaking of being tan. It was actually, you probably know this in New York City for some of the people who grew up here. I grew up in Staten Island, and I am very familiar with the culture of the Jersey Shore, unfortunately. And one of the provisions of Obamacare is actually a tanning surtax. That's actually an excise tax on tanning. So it made taxing very expensive. Snooki got all upset that she was voting for McCain. But this actually happened. Anyway, back to Pelosi. Pelosi had a challenge. She had to pass a bill that was different than the one that came out of the Senate. But you couldn't send it back to the Senate because we filibustered. So what did they do? Reconciliation. Does anyone actually know what reconciliation is? Usually that's a process where the House and the Senate go back and forth on versions of a bill to kind of iron out kinks, right? Is that what Pelosi did? No. She took the entire 2,700-page bill, crossed it all out, and added another 2,700 pages. She basically rewrote the entire bill without it going through the Senate again. It would eventually go back through the Senate, but under the reconciliation process, which is not subject to the filibuster. This was parliamentary brilliance. She was able to rewrite the law without having to go through the filibuster. Genius. They didn't have separation of powers or anything. It worked. So here's the final vote. What is it? 219 yay, 210 nay. Right? 34 Democrats crossed the aisle. That vote was close. The Democrats should have had that by a landslide. That vote was close. And you might remember that number of pro-life Democrats like Bart Stupak and others effectively changed the vote at the last minute to give them enough. It was part of this executive order that had no merit. So the law passed the House. It would eventually have to go back to the Senate, pass with the reconciliation, but that doesn't really matter. Went to the White House. We had this big, bold signing ceremony. President Obama is so happy. You see here, there are actually 23 pens. They use this commemorative pens. He actually signs a signature in parts. Like he makes a stroke, new pen, to give these away. So happy, the kid's looking on, he's just thrilled. He's thinking, this is it. We got Affordable Care Act. This was March 2010. Wow, we're done. This is a piece of cake, right? No. So, within 8 minutes of his ink drying, a federal lawsuit was filed. There was a race to the courthouse between Florida and Virginia, who can file first. Florida got it first by about 8 minutes. They filed a lawsuit challenging the law. Now, a lot of you haven't taken constitutional law, so I'll give a little bit of an overview. The big problem with Obamacare is what's called the Commerce Clause. Is anyone familiar with what that is? A little bit? Okay. So there's a very famous case. Who knows what case is from the pictures? See if I can figure this out. What is it?
Wickard v. Filburn.
Good. So there's a case called Wickard v. Filburn from the 1930s. This guy, Farmer Filburn, right? He grew wheat in Ohio. At the time, the federal government had a law saying you could only grow so much wheat. They limited how much wheat you could grow. And he said, wait a minute, Congress, the wheat I'm growing is just for me, my animals, my family, my farm. No one else is using it. How can you possibly tell me what to do? None of this wheat crosses state lines. But wait. This is Claude Wickard, this menacing Secretary of the Agriculture. These little forecast charts in the background. He says, nuh-uh. Your decision not to sell wheat on the interstate market affects prices. I'll say that again. By you not selling your wheat, you're not buying it from someone else. You're affecting prices. Because you affect prices, you're affecting commerce. Okay? Supreme Court said, yeah, that's right. Even if something doesn't leave state lines, Congress can still regulate it. It's what we now call the Commerce Clause, kind of like a Wolverine thing. Which brings us to this case. Oh, super extra credit for anyone who knows who this is. Who is this? Anyone know?
Raish.
Good, I didn't know that. That's impressive. I'll give you an autograph later, it's good. This is Angel Raish. She suffers from very, very severe cancer. Okay, now we're in the village. Who knows what that thing is?
Vape.
I agree with this a lot. Okay, so now I know why you know Raish is.
No!
Go party with her sometime. Get some Cheetos or something. So, we're going to talk to some really old people. They don't know, what is that thing, a humidifier? No, okay. This is a vaporizer. She uses it to consume medicinal marijuana. The only treatment that actually alleviates her symptoms is pot. Nothing else. That alleviates her symptoms. It's marijuana. Okay? Under California state law, as in several states, medicinal marijuana is legal. As I'm sure many of you might know, under federal law, it's not. You can't have marijuana under any circumstances, not even prescription. So she had marijuana grown on a farm near her house, and she consumed it. The marijuana never crossed state lines. It really didn't come off the farm. Congress said, the government said, we can regulate that. You can't have this marijuana. The case went to the Supreme Court, argued by, who's who this guy is?
Randy Barnett.
Randy Barnett. Humble brag. Randy Barnett. He argued this case. It's called Gonzalez v. Raish. He lost. Why did he lose? Because the Supreme Court, and in particular Justice Scalia, said Congress can regulate any kind of commercial activity that impacts interstate markets. What the market is for marijuana, I won't ask you. There's no legal market, but in Justice Scalia's mind, there's some sort of market for marijuana. But they said you can regulate this activity that affects markets. Okay, no big deal. This is actually Angel Raish on the phone when she found out she was crying. She was pretty upset. She's actually still alive, but she's quite ill. Which brings us to the broccoli question, right? Ever remember this? If Congress can force you to buy health insurance, can they make you buy broccoli? Why would they make you buy broccoli? Well, broccoli makes us healthy, right? Broccoli is good for us. Everyone's mommy wants to give us broccoli, right? Because it'll make us healthier. If Congress can make, this is from The Simpsons, I love this clip. If Congress can make us buy health insurance to be healthy, why can't they make us eat broccoli to be healthy? This was the limiting principle question. If Congress can do this, why can't they do that? Where do we draw the line? If Congress can actually regulate your ability to purchase health insurance and make you buy something, why can't they make you buy broccoli? There's no actual constitutional merit to that framework, but it makes you think twice and reconsider how the government works, okay? Okay, everyone go to the common law part? Okay. That brings us back to the law. And you can actually see here, his inability to draw an O is because he used 23 different pens on it. Okay? So we have the race to the courthouse. And it was a race, I'm not kidding you. Virginia actually got in about 20 minutes late. They had problems with the electronic filing system. But they were trying to get there first. This was going to the Supreme Court, everyone knew it. Okay, so this guy you might know, who knows who this guy is? Cuccinelli, yes, he is actually running for governor of Virginia at the moment. He was Virginia Attorney General, he's actually in London Law School. Cuccinelli filed the first suit in Virginia. And actually Virginia broke off from the other states. There were, at the time, about 24 states challenging this law's constitutionality. Virginia broke off saying, hey, we're special, we do something different. Why? Because Virginia passed this law that effectively said it's against the law in Virginia to make someone buy health insurance. Now, for any of you who know about supremacy clause, federal laws will trump a state law. A state can't pass a law banning a federal activity. That's pretty easy. I'll go into the details you want later, but his suit was actually in bad shape. Even though he had a pretty weak suit, the district court ruled for him. This is my angry Obama picture. He was mad here. The district court ruled for him. And this was the first blow against the presidency, because at the time, most academics, and Professor Friedman included, myself included, thought this case was stupid, open and shut. This is a medicinal marijuana case. Health insurance is a multi-billion-dollar industry. How is it possible that Congress can't regulate it? It doesn't even make sense. If they can regulate marijuana, which is like, a few dollars, how much does it cost for?
Oh my gosh.
Oh, you got it, yeah. A few bucks, right? It's cheap. But we're talking about a billion-dollar industry like healthcare. How is that not Congress? Okay, so Obama wasn't happy here. But the law continues to be unpopular. Actually, I made this presentation a while ago. If we substitute the word healthcare for Syria, I think the cartoon works also. Oh. Did that joke bomb? I won't drone on, okay. So let's go to Sunshine State. My students are very unfortunate. So the second big case was in Florida, and this was the main attraction. This was that 26 states filed suit joined together in Florida. And they were asserting that the Obamacare law was unconstitutional. This was Judge Fred Vinson, and in probably the most significant early opinion, he wrote a very long and comprehensive judgment finding that Obamacare is constitutional. Why? Because for the first time ever, Congress was regulating inactivity. They weren't regulating activity that is buying marijuana or growing weed. They were regulating the decision not to buy health insurance. All of you sitting here are doing absolutely nothing. You're not even paying attention, I'm sure. You're just waiting for the food to come. You're doing nothing. Can Congress regulate your decision to sit here on your butt and do nothing? This judge said, no. The Supreme Court had never before sanctioned this expression of activity. It was
unprecedented.
Thank you, unprecedented. It was unprecedented, that's not the problem. It was unprecedented. Congress never before had done this. But the mere fact that something's never been done doesn't make it unconstitutional. But this made it clear that the Supreme Court would have to resolve this issue. It had never been done before. This is my other Obama angry picture hanging his head in shame. Because I imagine he was not too happy with this judgment. Because now, although he had a couple victories, you had 2 district courts who ruled against him. And this was very significant. So, on to the courts of appeals we go. Jingle all the way. The main 2 advocates. Okay, let's see. Extra credit. I'll autograph a book plate. Who's this?
Neil Katyal.
Katyal, good.
Paul Clement.
Good. Okay, so these are 2 of the top Supreme Court advocates we have today. Both brilliant lawyers, very gracious, very, very, cool people. They would face off each other in several different courts of appeals and argue about this case. And the government's strategy got a little bit better at the courts of appeals. The first case that was argued was actually at the Sixth Circuit Court of Appeals. And this case actually came out on a surprise. So, all right, this is really good. Who knows who this is?
Jeff Sutton.
You find clerkships?
He's coming here in a couple of.
Is he talking about Marbury?
I'm not sure if he's talking about.
Okay, this is Judge Jeff Sutton. He's in the Sixth. Oh, you're from Columbus. Of course, you know what this is. Oh no, not from Columbus. Okay, so this is Judge Jeff Sutton. He's a judge in the Sixth Circuit Court of Appeals. Bush appointee, very conservative. He actually ruled in favor of Obamacare, and this was viewed as a huge victory. This is my happy Obama picture. He viewed this as a huge victory because, like, look, before every single judge who had ruled against Obamacare was Republican, right? Here we have a Republican voting in favor of Obamacare. That was a very big deal. And people said, listen, things are going to be normal now. Like, look, this stupid argument about activity and inactivity and marijuana, whatever, it doesn't matter. But then we go to the main show. It's the 11th Circuit in Georgia. Okay, these you're not going to know. This is Judge Hull, and this is Judge Dubina. It's a little trickier. These were two judges in the 11th Circuit. This was the main appeal, though, because this was for the 26 states that were joining together. Remarkably, these two judges, she a Democrat, although a conservative one, he a Republican, joined together to strike down the law. For the first time, you had a Court of Appeals voting against a law's constitutionality. This was significant because why? It creates a circuit split. And what happens when we have a circuit split? Say it. Supreme Court, yes, Supreme Court resolves circuit splits. So we had now a circuit split. I love this cartoon. But the court here did what Congress couldn't. They stopped this law. And we could debate for years about the merits of the constitutional law, but they voted that way. And this is my Obama stop in the name, stop picture. He had to stop this. Next case went much better. No one really cared about this one. This was in the Fourth Circuit. They wrote this kind of weird opinion based on taxing power that no one really thought was correct. But they upheld it, and here's my happy Obama picture. Okay? So now we're getting ready for the fun stuff. Okay? Actually fitting, I'm drinking water before this next guy. Who knows who this is?
Don Morelli.
Yeah. Solicitor General, all right, of the United States. The Solicitor General of the United States came on board shortly before the case was argued in the D.C. Circuit. Neil Cocktail had to step aside. He was not made Solicitor General, so we now have the D.C. Circuit case. There was a slight change in the strategy, and I'm going to have to bore you with a little bit of details about tax law. Has anyone actually heard of the Anti-Injunction Act? Okay. What is it?
Basically, you can't raise a legal challenge to a tax until you've paid it.
Right. So has anyone ever had an IRS dispute? Okay. The general norm is if you have a dispute with the IRS, you pay the tax first, and then you can sue. You can challenge it later. Can you imagine how disruptive that would be to the IRS if people start suing before they pay their taxes? They never pay that. So this law was passed like 130 years ago. It's been in the books forever. So initially the government argued saying, listen, this Obamacare law is a tax, right? And because it's a tax, you can't sue until it's collected. And when is it going to be collected? In 2014. Hasn't even happened yet. So originally the government said the case is not ripe yet. You can't sue for a few more years. The big problem with that, though, is that the Affordable Care Act is not labeled as a tax. In fact, it's clearly labeled not a tax. Congress went out of their way to make sure that this was not construed as a tax. Why? Because this guy in 2008 promised, I will not raise taxes on people under whatever. Remember that? He did not want to break his campaign pledge. So, and whoever wants to raise taxes, right? So Congress was very clear saying this is not a tax. It was labeled a penalty. Now, you might think, oh, what's the difference between a tax and a penalty, right? Well, it makes a big difference. Because the Congress has the power to raise and collect taxes. That's a very broad power. That's how Social Security is back, taxes. But their power to implement a penalty is more narrow. It has to be premised on their ability to regulate interstate commerce. So if the law is not a penalty, or if it's not a tax, it must be based on the Commerce Clause. And if Commerce Clause loses, then it can't be a tax. really looked at the case differently. He said, all right, wait a minute. I'll agree that this law is not written as a tax. That's not what it says. But you as a court have an obligation to uphold the law if you can find a way to do it. He said, the most reasonable way of reading this law in order to uphold it is to view it as a tax. Even though it's not labeled as a tax, you should pretend. Like Mr. Rogers, Imagination Land, pretend it's a tax. This is how it would be a litigant case. Pretend it's a tax, and then you can uphold it. At the DC Circuit, we saw the first glimpse of this strategy framed in that way. It was what ultimately John Roberts called his saving construction, but this was actually a bit early. And who knows who this guy is? Did I stump you? Oh, he'll be upset. This is Judge Brett Kavanaugh. He's in the DC Circuit. He was Bush White House counsel. The guy's brain is like the size of like New Jersey. It's huge. Really smart guy. He had one sentence in his opinion where he said, you know, if this statute was a little bit different, like if you changed a few words, it would clearly be a constitutional tax. I mean, obviously to change a few words means you're rewriting the statute, right? He said, well, you know, we can like pretend, you know, pretend the word penalty is not, but let's pretend the word tax is there. It's constitutional. Okay? So they won the DC Circuit, and notable 2 Republican judges, Kavanaugh and another judge named Silverman, voted in favor of it. So now we have all these Republican judges voting in favor of it. Happy Obama. But now we're going here. So who here's actually been to the Supreme Court? Oh, good. Everyone should go. Just get on the Amtrak, Union Station, walk 10 blocks through there. You should definitely find a way to go into here. The Supreme Court granted cert on this case. Initially, it wasn't even clear if they would have certiorari, but they did grant it. And here are all the justices, looking all happy. In fact, this picture of Souther is wearing a little neck doily. Justice Ginsburg gave it to her. She hasn't worn it since. She's a village girl. She does not like wearing neck doilies. Yeah, she actually gave one to Kagan. Also, Kagan stopped wearing them. I swear. Does anyone actually know what's officially called the neck doily? Do you know what the official term for that is? A jabot. J-A-B-O-T. And if you go to the Wikipedia page for jabot, I'm actually in a footnote. So I think I'm the only person in the world that actually cares about these things. It's true. So, we will soon have this clash in the court. And a little history is coming back. So who here knows what this picture's from?
State of the Union.
Oh, what happened State of the Union?
Alito shook his head.
Why did he shake his head? Who knows why he shook his head? Yeah. Citizens United, right? He's like, arr. We need at least one animated GIF. I promise I don't have. At the State of the Union in 2010, which was roughly a week after Citizens United was decided, the president made a statement how this case opens the floodgate for foreigners to spend an election, and it was, you know, the worst thing ever, and whatever. And Alito was like, not true. He wasn't actually shaking his finger. That's a GIF. But he did shake his head saying, not true. We've seen here, though, something significant. President Obama was not in the least afraid of using his pulpit to talk about the court and to try to influence the court. This is very dangerous. We don't like the court to be political. The courts will make their rulings in perhaps partisan manners. We accept that. But there's a tradition in this country where people don't go after attacking the courts. I mean, what president most famously went after the courts? Roosevelt. That didn't turn out too good. Didn't turn out too good at all. This president has made it clear that he's willing to do this. And this paints the climate of how Obamacare was decided. Obamacare was not decided in a vacuum. This was not your average run-of-the-mill case. It was decided in a very contentious political environment that was in an election year, right? The election was 4 months after Obamacare was decided. And that's the climate we consider this case. So, when I said before you should all go to the Supreme Court, I forgot to say you can't really get tickets unless you know someone. They don't give out tickets in advance. If you don't know someone, the way to get tickets is to sleep outside. And for any given case, you might have to just sleep on the sidewalk. I've done it about 3 or 4 times. I'm warning you, at 3 a.m., the sprinklers go off. And it's very cold. It's very cold and wet when you're lying on First Street and the sprinklers go off at 3 in the morning. It sucks. But I got it. For this case, one woman waited 92 hours for seats. She waited on the street for 92 hours to get in. If you ever need an argument why there should be cameras in the Supreme Court, this, okay? But then we had the protests, and it was actually kind of a circus-like atmosphere with all these Tea Partiers and Obama ralliers, and these people were just going crazy outside. Yeah, you have to listen online. So we all listened on C-SPAN, okay? And here are our 9 wonderful starring justices in this production. So, of course, we have no cameras, so I have drawings of what happened. The Obamacare case took place over the course of 3 days. This was one of the longest arguments in like 4 decades. This hasn't happened in a while. And the first day, this is Don Verrilli, Solicitor General, and this is Paul Clement, who was actually Bush's SG, and who will probably be a justice in the next few years. So Verrilli was up first. I'm going to go back to this picture. Verrilli was up first. And on day 1, the issue was the Anti-Injunction Act. And he had a very odd argument to make. What was his argument? His argument was, listen, this law, for the purpose of the Anti-Injunction Act, is not a tax. Why? Well, if it was a tax, you couldn't hear it until 2014. So if Verrilli was saying, listen, I promise you, this is not a tax. This isn't a tax. Go hear this now. Don't decide this when Mitt Romney's president. Decide this case now. Right? Okay. That was on one hand. On the other hand, Your Honors, this law is a tax for constitutional purposes. At the same time that he was telling them it's not a tax for purposes of the Anti-Injunction Act, he was telling them that it was a tax for purposes of the Constitution. Try and figure that one out. The same law can be a tax for one reason, but not another. It was a difficult question, which he admitted was something that, in court that was, not obvious, but he made the argument. And I'll tell you something, very few people picked up on this argument at the time. Almost no one noticed it, except people really closely involved. But after the first day, at the first day, John Roberts actually asked the lawyer for the challenger, saying, hey, listen, the Solicitor General just said that, it's just a tax. Why shouldn't we construe it that way? And the lawyer basically said, there's nothing stopping you. If you are so inclined to save the law that way, that will happen. So on day 1, John Roberts was already telegraphing his vote. It was a surprise to me, but if you go back and you read the transcript with hindsight glasses, he actually had in mind a possible way of saving this law. Day 2 was a Commerce Clause day. This was a day for deciding whether this law satisfied the Commerce Clause requirements. And the Solicitor General, he had a problem. So it's the tradition of the Solicitor General to do 2 moots. Oh, your voice is breaking. 2 moots before each case. He had 3 arguments in the span of 3 days. So he did 6 moots in the span of 1 week. Each moot was probably 2 or 3 hours long. So for any of you who've done mock trial or moot court, if you're talking for 3 hours straight, many days in a row, you lose your voice. He actually started losing his voice. So right before he went to the podium, to do this, he took a glass of water and I used to make a Marco Rubio joke, but it's not timely anymore. He went to the podium and he choked. He could not breathe. It went down the wrong pipe. He was literally choking. But if you listen to the audio, there's a 6-second gap of silence. And you can actually hear in the court him reaching for the pitcher and clinking ice cubes around. It's the weirdest thing. People who were in the court said it was extremely noticeable. You just went for a poker. No. I can't do this in Texas. So he choked. And he started off very bad. And it kind of went downhill from there. The main question that he had to answer was a question for the court. What is a limiting principle? Right? If Congress can make you buy health care, can they make you buy broccoli? My broccoli picture. This is Scalia broccoli. If Congress can make you buy health care, can they make you buy broccoli? All the justices asked him this question. And then he kept beating around the bush, he didn't want to answer it. And finally, Justice Alito, who was no fool, said, General, succinctly tell us, what is your limiting principle? Okay. So you will also be doing moot court and a mock trial and stuff. You have to know cold your main line, right? Your main argument you should know memorized. This is the most important lawyer in the United States at the moment. What do you think he said when he was asked this question? Did he rattle off a short, concise answer? The justice said concise. Was it short and concise? No. I won't bother with words in PowerPoint. I don't believe in words in PowerPoint. But it was long. You can read it in the book. It's quite long. He gave this 45-second rambling answer that didn't make anyone happy. It offered no tangible limiting principle. Now, I will come to the defense of Verrilli. I will defend him. It was intentional. What he said during that colloquy was exactly what he had said in his briefs. In other words, he didn't do a good job delivering it. But what he said was no different than what was in his briefs, and that brief was read by every government lawyer from Obama down. So what he said was the approved company script, so to speak. Writing a brief for the government, if you've done government work, is not the same thing as writing a brief for a private party. You have certain institutional constraints that limit what you can say, which people don't appreciate. The government couldn't just pick any limiting principle, because if they take this position here, that might bind them in a future case. Now, you might say, this case is unlike any other, we should throw everything at the wall. They didn't do that. So he took a position. No one bought it. This was a reckless gamble, and it lost. 5 justices rejected his Commerce Clause opinion. So at this point, he bombed the Commerce Clause opinion. He pretty much bombed the taxing power argument. The only thing that was in his quiver left was the saving construction argument. The idea that, listen, if you can save this law, you should. This approach wasn't premised on any kind of constitutional law or visions of the judiciary. It was a restraint position. Scalia hit him over, and he made a lot of bad jokes. Okay? So after the arguments, everyone thought that the case would come down to this guy. Everyone knows who this is, right? Tony, right? Yeah, Tony Kennedy, Mr. Dignity. This is Justice Kennedy. Everyone thought the case would come down to him, but no, it was this dreamy-eyed man from upstate New York. Who is this?
Roberts.
The chief. Isn't he dreamy in that picture? He's like this deer in the headlights gaze. Oh my God, I'm actually a justice. This is from his confirmation. So Roberts is the actual person who's inside this case, which was not understood. And there was a lot of pressure on Roberts, and there were a lot of leaks, and rumors of leaks, that the chief changed his vote. I'm not going to get too far into the leaks as much to say that there was a lot of stuff going on in Washington, D.C. that people don't realize. There was a concerted effort on the parts of many conservatives, some of the names you'd actually recognize, to try to influence the justice. There were a number of op-eds and articles published saying, hey, John Roberts, grow a backbone. Don't change your mind. These op-eds were not written accidentally. They were written because these people knew the chief was on the fence. What I'm trying to convey is the leaks were known much earlier than you knew that. They were known even as early as May. I'll one-up that. The president took it upon himself to get involved in this. How? 3 days after arguments, actually the next weekend, Monday, the president made an impromptu speech. I found Obama's best when he was off the teleprompter. He's actually much more articulate. I actually like him much better. But he says stuff he probably shouldn't. 3 days after the conference, the president said, quote, the court should exercise its jurisprudence carefully. The court, Obama actually referenced Lochner. I don't think George Bush even knew what that was. But he actually talked about Lochner. For God's sake, the president's talking about Lochner. This is the case, this is like Dred Scott and Core Monster combined for most liberals. This is like the worst thing ever. The idea that the court should police the court should strike in economic regulations, right? The president effectively said if the court strikes this out, they'll be like the Lochner court, that they shouldn't do this. These are powerful words coming from the president in an election year. And in my mind, this is a preview of things to come. Here they're all chummy, right? But Roberts felt the pressure. He had to have felt the pressure because he knew everything around him. So he made the choice. I love this cartoon too. Roberts voted to uphold the law. Obama says, this is not a tax. And Roberts says, this is not a penalty. This is no longer protection against government intrusion. What Roberts did was he recharacterized the mandate. Even though the Obamacare law clearly said this is a penalty, he rewrote it as a tax. And because it's a tax, Congress has broad power to regulate it, even if it's not commerce. So, it says, I murdered 12 people, what are you in for? I didn't buy health insurance. This is how Obamacare was written. Under the original Obamacare law as written, it was, well, it wasn't quite a crime, but it was actually not allowed to not buy insurance. If you didn't have insurance, you were punished. But as the government argued, listen, if you don't buy insurance, just pay the penalty, there's no consequences. That was not the law that was passed, that was the law that was upheld. Strikingly, we had a very bitter joint dissent by Scalia, Kennedy, Thomas, and Alito. They would have voted to strike down the entire damn thing, all of it. All 2,700 pages that have gotten rid of it. Clarence Thomas dissented separately, saying, screw it, I'd reverse the 20th century. Being completely slightly facetious, but Justice Thomas dissents fairly often to say, I'd reconsider like every case before after 1936. Many Collins, and he's not a big believer in stare decisis. He's not. It's like, what you talking about? And he doesn't care. The interesting votes, though, I didn't talk much about the Medicaid expansion, but there was another provision of Obamacare that expanded Medicaid to people who weren't quite as poor. And the court actually, in a vote of 7-2, found that this was an unconstitutional violation of the spending clause. That is, Congress can't spend money in a way that's coercive. And interestingly enough, Kagan, see, she's wearing a modified neck doily there, and Breyer voted in favor of it. Only the queen of the neck doily, Justice Ginsburg, the diva herself, she actually said if she wasn't a justice, she'd be a diva. She actually wanted to be an opera diva, so I'm not being facetious. And Justice Sotomayor said that the entire law is constitutional. RBG, Ruth Bader Ginsburg, said that this law is just like Social Security, it's part of the safety net, of course it's constitutional. The fun stuff, though, happened outside. So because the Supreme Court has no cameras, everyone got it wrong. This is my favorite headline from CNN, mandate struck down. If you actually read the first 3 pages of the opinion, it looked like they struck the law down. And if you turn to page 4, it says, oh, by the way, it's constitutional as a tax. CNN ran with it after only reading the first 3 pages. And they blared to millions of people that the law was unconstitutional. But there was one person in particular watching this who was very worried. He was watching CNN. That's his first mistake. The president was watching CNN. And for 10 minutes, the guy thought this law was unconstitutional. He didn't even know. Fox got it wrong also. Good old Megyn Kelly, she'll be in primetime soon, I guess. She got it wrong also, though she actually recanted quickly. She's like, wait a minute, SCOTUS blog says it wasn't. But eventually we have Happy Obama. His White House counsel said, hey, you're good. Dewey defeats Truman, right? It's constitutional. And in my mind, Solicitor General's been vindicated. He took a gamble. Some of it didn't work. Some of it did. John Roberts, who did some surgery, was lambasted. Glenn Beck, who I guess was still on TV at the time, ripped him apart, called him a coward. This guy, what's his name? Willis or something? Or yeah, whatever, Romney. He was running for president, in case anyone forgot. I sometimes forget. I actually saw a Romney sticker on a laptop at Columbia before. I was like, really? He had a press conference moments after the Supreme Court decision that we need to repeal and replace Obamacare. What people forget is in Massachusetts, he implemented a very similar version of Obamacare called Romneycare. It had a mandate. Yes, there are differences between state and federal laws, but no one knows about that. So in the debates between Obama and Romney, the Obamacare issue was basically dead because he was the worst possible Republican candidate to run this issue. He implemented it in his own state. Every single time at a debate, he brought it up. Obama said, well, you did it first. Obama actually called Romney the godfather of Obamacare. You're just playing into your opponent. So Romney lost, and we're still in wars with other countries, I guess. But this is actually swearing in number 3. This is at the this was in the White House where John Roberts was there. Funny story, but Sotomayor was actually supposed to swear in Biden, and Sotomayor rescheduled on Biden because she had a book signing in Union Square. She rescheduled Biden so she could make her book signing. Oh, but she also won the Daily Show. She didn't tell him about that till later. That's why she had to go to New York. So Jon Stewart over Joe Biden. I guess that's a proper hierarchy. And they shake hands, and Robert's like, asshole. I was like, thanks, buddy. So we're stuck with this law. Healthcare is still going to be expensive. We still have the Constitution. This case presents a nice dichotomy. But what's interesting is this guy's going to be gone in 3 years. He'll be gone in 30. And I think we need to keep that in perspective. You will all be adults, and you'll be like retired, and Roberts will be the Chief Justice. He's going to be here for a very long time, and he has a very long career. He's looking forward, right? And he was willing to save the Obamacare law for what would happen to come next. And we saw the Constitution, and it's the string that binds us all together. And that's why this case was so unprecedented. It brought together so many constitutional challenges from all branches of government at one time in this perfect storm of this constitutional challenge. And that's why I wrote the book. Thank you very much.
Where do we buy the book?
Outside. Good question. Yes, sir.
I wonder if you can talk some about the decision to strike down the Medicaid expansion. Just kind of any thoughts you may have on it.
So the Medicaid expansion, I didn't talk about it much, but it effectively said that Congress was going to give states money to take care of poor people, right? To give them health insurance. But in the process of doing this, they had to accept this new money. If they didn't accept this new money, they would lose old funding. So basically, if they said no to this one program, they would lose all their funding. What the Supreme Court said was, that's coercive. It's not really a choice to say, you can accept this money or lose your old money. Okay? The Supreme Court, by vote of 7-2, says it's unconstitutional. But as a practical matter, states now have the choice. They can opt in and accept this new money. Once they accept this new money, they're stuck. My new home state of Texas will be the last one there. Rick Abbott will be in Alamo waving his rifle saying, for my cold dead hands. And they'll be the last ones. But one by one, all the states will fall into line. Good questions. Yes, sir.
I had not known the fact that I was asked a question about the taxation framework on the first day argument. That was mentioned to me. Based on your research, what is your opinion on the importance of the oral arguments? I mean, was the decision going to be basically the same before the 3 days, or did any of the arguments over the course of the 3 days really influence any of the justices?
So I think actually, yes, they made a difference here in two respects. In one respect, the saving construction I mentioned was written in literally 2 paragraphs in the government brief. It wasn't focused. Yet really, on day one, spent nearly half of his argument talking about it. He made that point abundantly clear, and Robert picked up on it. A second issue, something that wasn't even mentioned in the briefs, was actually cited in the joint appendix from the lower court opinion, involved the Medicaid issue. So shortly after Obamacare was announced, Arizona, Governor Jan Brewer, wrote a letter saying, hey, Medicaid, what happens if we don't take this money, right? HHS, Health and Human Services, wrote back saying, if you don't take this money, you lose all of your funding. That was in the record and had been forgotten about until Paul Clement, whose brain is the size of Montana, remembered it and said, oh, Chief Justice, this wasn't in our briefs, but in the joint appendix, page whatever, that's Clement, there's this letter from Arizona. And Robert said, yeah. Then he asked Brewer, like, what about this letter from Arizona? Tell us about that. And then Brewer was like, humana. He knew that question was coming, right? He knew that was coming, but he couldn't answer it. If you're a lawyer, you say, Your Honor, we promise we won't take away all this funding. But he couldn't say that. Why? Because HHS wanted to reserve that power. They knew there was a risk by giving that answer, the court could rule against them. And there's actually a colloquy where Roberts is hitting him really hard, saying, what about this Arizona letter? What about this Arizona letter? I think that actually signaled a turning tide in the issue. Even Breyer and Kagan were getting irate because the government refused to acknowledge that they had that power. I think that telegraphed it. Of course, hindsight's always 20/20. Yes, sir.
You said that Roberts was looking forward with this decision. What do you think he's looking forward to?
Striking down the Voting Rights Act? I mean, the book went to press roughly a month before the Voting Rights Act was decided. Listen. This guy's going to be out of court for 30 more years. We don't even know what he's going to need. But the court has to maintain some sort of institutional credit, right? And I really fear what the president would have done, who would have not taken the higher road. He would have attacked the court during the presidential election. And that could have long-term implications of what the court does. I mean, Obama, I don't need to... He has shown that he's willing to criticize the court when they haven't really done anything to him. Citizens United really didn't deal with him. In fact, he spends so much money under Citizens United, that's another point. We know, though, that he's not willing to criticize, to praise the court. Answer the question there?
Yeah, so it's kind of a follow-up on that. What do you think, so two-part, what's the implications for like Commerce Clause jurisprudence? And secondly, what do you think Roberts is gonna, like in 30 years, what do you think his legacy will have been?
Okay, well, the first question is, I don't think there'll be much of implication for the Commerce Clause. Why? Because the opinion itself is limited to the question of whether Congress can regulate inactivity. So unless Congress starts forcing us to eat broccoli or something like that, probably not much more application. Where it does matter, though, is it signals the willingness of the Supreme Court to police the outer bounds of Congress's powers. That is, they will continue through Federalist and Revolution the Roberts Court, of the Rehnquist Court. They're untapped. Now, your second question, what happens in 30 years? We don't know. If I were to tell you on September 10, 2001, that 12 years ago today, that the Bush presidency would be defined by the ability of Ted Olson to argue in the Supreme Court that he has the ability to detain people at Guantanamo indefinitely, you'd say I'm freaking crazy, right? If I were to tell you, like, November 4th, 2000, that in 36 days the Supreme Court will decide that they have the election, you'd say I'm crazy. If I were to tell you in 2009 the Supreme Court will come within this close of striking down a massive health care law because it's not in state Congress, you'd say I'm crazy. You're all smart kids. You're going to be the lawyers of tomorrow. You don't know what these arguments will be. You'll be making these arguments when the need arises. And when there's a strong political and social movement behind it, this becomes much more powerful. Good question. Yes, sir.
Just curious, regarding the circuit split that sort of led to the petition, the Cert petition in the first place, is there any speculation as to whether or not that was kind of a tactical move on the part of the circuit to...
Just split it and let it go?
Yeah.
I don't know. I mean, we'll never know why they voted. I like to think that judges vote the way they do because they think that a case will be resolved a certain way, not for partisan reasons. I'll let you guys do that from there. Whether judges actually did that or not, we don't know. In the back?
Is there any constitutional basis or precedent for justices to read something into a law that wasn't written there? Has it happened before?
Yes, in fact. One of the Solicitor General's biggest contributions, I'm going to nerd out a little bit. Anyone know the case of New York versus United States? It's a commandeering case, we'll study it. It's not too important. But there's one line in Justice O'Connor's opinion where she basically said, listen, this law is framed as a penalty. But to save its constitutionality, we'll read it as a tax. O'Connor said it. It was joined by 5 Republicans. 5 conservative judges, I gave it away. So, it was done before. Really cited that sentence for the first time in the Supreme Court briefs. No one had noticed that before. It was right there. And that's what Roberts used to decide the tax issue. So he percepted that. He saw that.
This is a pretty appropriate question, but reading Jeff Friedman account of this, one of my favorite tidbits was, and a few weeks before the opinion was handed down, Justice Ginsburg gave a speech to some group and said that this term has been very taxing.
Yeah.
Did your research uncover whether that was intentional and some sort of indication as to where the folks go?
I love Justice Ginsburg. She's extremely witty. Maybe she was trying to pull a pun on all of us. Jeff's hindsight glasses are very good there. No one picked up on that at the time. What was picked up was that she looked very happy and ebullient at the time. In the court, though, I wasn't in the court on decision day, but I know people who were, and they reported back. Roberts looked pale and drained. Sotomayor looked ghastly and pale. Scalia looked so angry. Like he actually pounded his fists on the table when he got there. Kennedy, who's usually very composed and continental, looked indignant. Thomas was not even laughing. And when people think he's silent, he's actually very jovial. It was a very contentious bench. And funny, Roberts, shortly after the event, he went to Malta for a summer program. And he said, I'm going to retreat to my impregnable island fortress on Malta, which I love that line. He got the hell out of town. Because he's a FedSoc thing, you should know that a lot of Federal Society people were just, in the Federal Society, were just unhappy with Roberts. It's like, we got our guy in there, he voted against us. This is even worse than Anthony Kennedy. We got George Bush in there, twice elected, and we got 2 justices in the chief, and we lost. So there was a very strong sentiment against what Roberts did. This term, they voted to strike down the Voting Rights Act because people are happy. But we'll have many more constitutional black swans for the next 30 years or longer. I don't want to distract you from food. Any other questions? Come up later if you have a question. I'd be happy to do autographs or a book plate for anyone else. Thank you so much for your time.